Case number 116542 in the matter of Ricky Edward Hodge, Jr.
Good morning. May it please the court. Deborah Hughes, Deputy Disciplinary Administrator on behalf of the Disciplinary Administrator's Office. Mr. Chief Justice, I'd like to reserve 7 minutes for rebuttal, please.
7 minutes is granted.
This is an original action involving attorney discipline. This case is before the court after a 5-day hearing before a hearing panel. The hearing panel found that the respondent, Mr. Rick Hodge, violated the Kansas Rules of Professional Conduct and recommended disbarment as the appropriate discipline. Mr. Hodge filed exceptions and a brief challenging the hearing panel's findings of fact and conclusions of law, and in doing so contends that the evidence failed to establish any rules violations. He also challenges the recommended discipline and argues alternatively that if discipline is necessary, he contends that admonition is the appropriate sanction. Presumably, I think he means unpublished censure, although I'm not sure, maybe published censure. This case, I understand that the court has read the briefs and is familiar with the facts. This is a very factually dense case tried over 5 days, and so I would like to go over the basic factual framework to provide some context for the issues that we will be discussing in this argument for the people that may be listening to this. This case arose out of a complaint that was filed by L.A. I will refer to her as Laura throughout this argument. This complaint was filed against Mr. Hodge by Laura. Laura was the CEO and 99% shareholder of a landscaping company called Complete Landscaping Systems. It's referred to in the briefs and in the testimony as CLS, or alternatively Complete. Complete was a Wichita-based company that provided landscaping services both locally in the Wichita area and nationally. It had been a successful company, a multi-million-dollar business company, but by June of 2013, it was in severe financial trouble. It had well over $1 million in unpaid federal employee withholding taxes, as well as unpaid state taxes, both in Kansas and other states across the country. It was being sued in multiple states by vendors it hadn't paid, and new claims and lawsuits were coming in daily. It didn't have enough revenue to meet its basic operating expenses and was having trouble even making payroll. Laura was also in serious financial trouble herself. She lived in an 80-acre ranch in the Wichita area that she and her then-husband, P.S., we'll refer to as Peter, purchased in 2010 for $2.25 million. It's known as the Michaud Ranch. By late 2012 or so, that mortgage had been paid down to around $565,000. But by June of 2013, she was over $100,000 behind in that mortgage. The rental payment, or the monthly mortgage payments, were $25,000 a month. She had been working with the Morris Lang firm, who was representing the mortgage holder that was the Michaud Trust. And they had been trying to work with her. She had been trying to obtain some kind of financing or anything to help her with that, but eventually, I think it was around April or March, they told her that they would be begin the process to initiate foreclosure proceedings. Now, Complete Landscaping Systems at that time in 2013 was represented by a gentleman, an attorney named Trinidad Galdian, who was at that time with the Hinkle firm. And he represented Complete on the creditor claims and all the litigation that was going on around the country against Complete Landscaping Systems. He represented Complete up to the point of judgment. He didn't handle, and neither did anybody in the firm, handle anything that had to do with post-judgment collection. And so one of those post-judgment matters was a case that Mr. Galdian had been handling in Texas against Complete. It was Haddon Landscaping, and Haddon Landscaping had gotten a $200,000 judgment against Complete in Texas Texas. They brought that judgment up to Kansas and registered it in Sedgwick County, which was where Complete's real estate was, their business headquarters and their land that headquarters was located on. So at that point, Mr. Galdian referred Laura to Rick Hodge to handle that post-judgment collection matter. Rick Hodge, the respondent here, is a Wichita attorney who does primarily Chapter 7 and Chapter 13 consumer bankruptcies, although he testified in the past he had done some Chapter 11 work as well. Now, on June 7th of 2013, Laura retained Mr. Hodge to represent Complete on a very limited basis, and that was to handle that Haddon Landscaping post-judgment collection matter. She signed a retainer agreement, and in that agreement it specifically stated that Mr. Hodge his representation was limited to that Haddon collection matter. However, almost immediately he began exploring Complete's financial situation, and within a week to 10 days, maybe 2 weeks, he was exploring Complete's financial viability and the possibility of a restructure or organization of the corporation. And as a part of that, he met with Complete's accounting firm and he went over its financials, and as part of that meeting with the accounting firm, he learned all about the full extent of its tax problems. He also obtained information from Mr. Galdian and from Laura herself about the extent of the pending creditor litigation that was going on across the country. As part of that, he learned about the breached settlement agreements. He learned many of those involved stipulated consent judgments pending those settlements, where if the settlements were breached, then a judgment would be entered. Urgent deadlines and upcoming trial dates in pending creditor litigation. And he also learned that Complete didn't have money to pay its creditors and vendors, and it hadn't been paying its lawyers as well. At that point in time, Mr. Galdian and the Hinkle firm hadn't been paid in a while, and he was withdrawing from pending cases, and he had put Laura on notice that he was not taking on any new cases unless significant retainers of, I think it was about $20,000 for each new case had been provided, or would be provided, which was impossible for Complete at that point in time. Complete also wasn't paying its local counsel that had been hired in many of these cases across the country. Complete also, he learned, that had a huge balloon payment of $300,000 that was looming on its business property real estate loan that was coming due in 5 months, November of 2013, and that had already been extended on a short-term extension basis from about March of that year. And he also knew that Haddon Landscaping was issuing garnishments against Complete's accounts to enforce collection on that judgment. He also obtained from Laura all of Complete's corporate documents and financial information, including its accounts receivable reports, inventory, cash flow reports, its balance sheet, its business property loan and mortgage documents, and its documents pertaining to the loan it had on its operating equipment. What's important about the balance sheet that he obtained was that it showed $2 million in shareholder loans that the corporation had made, which was a big red flag. At the same time, he also learned about Laura's personal financial problems. He learned that she was behind significantly on that ranch payment and that mortgage foreclosure was looming. He also learned from Peter, her former husband, that the equity in the ranch, which was significant, it was about $1.2 million in equity in the ranch, was the result of loans that Laura had made to herself from Complete Landscaping Systems, which was the $2 million in shareholder loans. After learning all of this, Mr. Hodge made a proposal to Laura. And this was the proposal, or the plan as it's referred to throughout the case, to help Complete deal with its situation. Complete would sell all of its assets to Mr. Hodge, or more precisely, to his business, Yard Concerns, his solely owned business, Yard Concerns. And Laura would sell her ranch to Mr. Hodge for the outstanding mortgage balance, which was about $570,000. The ranch appraised in September of 2013 at $1.8 million. That was the appraisal that Mr. Hodge obtained. Now, more precisely, again, this Mr. Hodge was not purchasing the ranch, but his solely owned business, Hodge Acquisitions, was purchasing it. Now, the full agreement on this deal was that the extensive equity in the ranch would secure his risk of loss in the asset purchase deal. And additionally, Laura would stay in the ranch as a tenant, and he would employ her at Yard Concerns at a salary that would allow her to pay the rent, and that she would she could repurchase the house for the price he paid for it, and that her rental payments would be applied to that repurchase. Now, Mr. Hodge told Laura, after he pitched this idea to her, that Complete needed to terminate its representation of her. He told her that, of course, not only did CLS not have any money to pay its attorneys, which he knew, but that doing so would, quote, facilitate the deal. He also told Laura not to file bankruptcy. In fact, he said that if Complete or Laura or Peter, who was the 1% shareholder, filed bankruptcy even personally, the whole deal would be off. He reiterated that to her repeatedly throughout the course of these events. So Mr. Hodge prepared the contract for sale of the ranch first, and it did not include any of the terms about the sale that he and Laura had agreed to, about the lease, the repurchase agreement, and the application of the lease payments, or anything about its tie to the real estate or the asset purchase agreement. Now, Laura signed it without legal advice. She believed that Hodge was acting as her personal lawyer, and she trusted him. After the ranch contract was signed, Mr. Hodge prepared the paperwork. This is like a day after it was signed. Prepared the paperwork for the asset purchase contract. And then Laura and Peter, the 1% shareholder, signed that paperwork through a corporate resolution that was drafted by Mr. Hodge. The ranch contract closed, moving forward through many facts that are in the record, but the ranch contract closed, but the asset sale began to fall apart after Complete's creditors learned of the asset sale through an article that appeared in the Wichita Eagle. Now, the evidence at the hearing from both bankruptcy experts that testified was that the asset sale was impossible from the start. Because of Complete's extremely dire financial situation, it was not possible for Complete to convey clear title to its assets other than by way of a Section 363 sale through a Chapter 11 bankruptcy. There were too many clouds on the title due to all of the judgments, pending creditor litigation, the mortgages on the business property, the tax debts that were owed. And so the only way that that could be accomplished would be through bankruptcy, Chapter 11, which provided a very handy mechanism for assets to be purchased free and clear of clouds on title, but through the course of a Chapter 11 bankruptcy. Now, one of Complete's creditors, Equity Bank, was privy to what was going on by talking with both Mr. Hodge and with Laura, who were telling him about the situation. Mr. Hodge had sent the asset purchase sale agreement documents to him. And he became quite alarmed about what he was hearing about this deal, and he referred Laura to Dave Aaron, a well-recognized and certified business bankruptcy specialist who met with Laura and promptly filed a Chapter 11 bankruptcy on behalf of Complete. Now, ultimately, again, fast-forwarding through many facts, Mr. Hodge did not get to keep the ranch. In the Chapter 11 bankruptcy, Complete went after the money that Laura had used to pay down the mortgage as a fraudulent transfer because that money belonged to Complete and it was in the house. And the ranch was ultimately sold and the net proceeds went to Complete's creditors. Now, although the Chapter 11 plan started out to be a reorganization, ultimately Complete was too far gone and it was unable to reorganize and it was liquidated in bankruptcy. With that background, I'd like to focus on several of the issues and submit issue.
Counsel, let me.
Yes.
Out of that factual timeline, would you highlight for me the things that you consider most egregious?
Pitching the asset sale to his current client without giving her full, objective, accurate advice about all of the options that were available to her. And by her, I mean Complete. Complete was his client, not Laura at that point in time. Actually, Laura's interests were adverse to Complete. That balance sheet showed that. When Dave Aaron, the bankruptcy attorney, saw that, he immediately told Laura she needed to get her own counsel because he saw the red flag immediately and knew that their interests were adverse. But as Complete's attorney, because he had expanded the scope of his representation, he wasn't just representing Haddon, or Complete on the Haddon judgment. He had taken upon himself to look at various other options like reorganization, restructure. He had the obligation in telling her one option, being his purchase of the assets, to tell her every other thing that she could possibly do on behalf of Complete in its best interests, And instead, he didn't do that. If he discussed bankruptcy with her, he gave her his one-sided view of it, and what she needed to know was the impossibility of an asset sale. The fair and objective advice that she would have gotten would have been, and both of the experts testified about the advice that she should have gotten back in June of 2013, would have been basically a 363 sale through a Chapter 11 bankruptcy. And that Chapter 11 bankruptcy was the only relief that could have been provided to this company at that point in time in June. All of the things that went along with it, although a reorganization might never have been possible, all of the benefits. One of the equity bank attorney called it a softer landing, even if it was never reorganized. The protection afforded by the bankruptcy stay, the ability to put aside and stop all that creditor litigation, the ability to have adequate protection payments, reduced payments to the secured creditors, all of that would have given it an opportunity to have more revenue coming in, to be able to pay its basic operating expenses, the ability to maintain some of its best contracts, and to consider that it could have sold its assets if that's what it wanted to do in the course of a 363 sale in Chapter 11. That, I think, was the most egregious part of this, coupled with his self-interest in he couldn't advise that because he wanted the house. And the reason he couldn't advise that is because the money went into the house. This was Pandora's box. This was why the two things were tied together. He couldn't advise that because the house could never be retained, because the money that made up the equity in that house belonged to Complete. And any attorney representing Complete in a bankruptcy had to, on behalf of that corporation, go after that house and pull that equity back and put it back into the company so that it was available either for operating or for creditors. But he wanted the house, and that's why he advised no bankruptcy. Bankruptcy will destroy this deal. And so getting the house from her and tying it to the other and telling her no bankruptcy together was the most egregious part of this. It was self-dealing at its worst.
So the nub of that, from your perspective, is that the evidence demonstrates that what Mr. Hodge hoped to get out of why he was doing all this was to obtain, at a significantly reduced cost, this ranch. That was the motivating factor.
A $1.2 million equity, right, in a ranch for $500 and some odd thousand. If he could get some of the assets of the corporation, that would be an extra bonus for his business, but I don't know that he ever really thought that was possible. I'm not sure on that, but
from your perspective, or at least it sounds like what you're saying, all the dealings and the advice with regard to the corporation was geared towards securing possession of the ranch.
Yes. So the primary issue that's raised in the respondent's brief and that was before the hearing panel was whether or not there was an attorney-client relationship. The reason that's important is because the 1.7 and 1.8 violations hinge on there being an attorney-client relationship at the time the business transactions were entered into. And the hearing panel found that there was an attorney-client relationship that continued beyond the email exchange on July 29th of 2013, in which Mr. Hodge sends an email to Laura saying, you know, this confirms our discussion of today's date on the phone in which we talked about you don't have sufficient operating assets to keep me on, and that you understand this is what will happen if you don't have representation. Judgments will continue to be obtained, and et cetera. And you've been advised that I have an interest in purchasing your assets of your company, that this may be a potential conflict, I think he says in there, that I won't be representing you, I will represent yard concerns. Nevertheless, you still want to go forward. You're not interested in any bankruptcy reorganization. Let me know if you still want to do this. And she responds 2 minutes later with a very short email that says, yes, please proceed. I no longer wish your services. Please proceed with the asset sale as discussed, which she testified he drafted for her, and then she promptly followed that email to him with one that said, was that response good enough? So after that, though, it was the evidence, as the hearing panel found, of essentially no change in their relationship. We have the benefit of text messages, constant text messages back and forth between Laura and Mr. Hodge that showed the nature of their relationship both before and after this July 29th termination. And it's astonishing to look and see the nature of the relationship. She continued to look to him to protect Complete's interests. That's the key. That's the key to the attorney-client relationship. He continued to represent to her that he was protecting Complete's interests. And he characterizes some of these things as other, that he was doing other things. But if you look at them, and I can give you some examples of ways that she looked to him to protect Complete's interests, and he indicated to her in response that he was taking care of her interests. He talks to her about how she should sell the building, Complete's real estate, and was also told her he was talking with Mr. Galdian about their unpaid fees. This is way into September after everything had already started, way after the termination. Well, the real estate building wasn't any part of the business transaction in any way. It wasn't part of the asset sale. And paying Mr. Galdian his unpaid fees wasn't part of the business transaction. So why was he advising her on this? Why was he advising Complete that they should do these things? It wasn't part of this. He says it was just part of the business negotiations between two parties at arm's length transaction, working out the details of this business transaction. No, this had nothing to do with that. He'd also been in contact with Hampel, which hadn't been paid for their gasoline because they had no money, and they were coming to take their gas tanks, which they needed so they could fuel their trucks for their local business to continue operating. And why was he doing that? The Haddon case, he didn't withdraw, and he continued to contact her and tell her about court appearances that were coming up. On the day of the court appearances, he would tell her, you've got a court appearance at 1 o'clock this afternoon, and she'd say, oh, I can't appear, and he'd say, I'll take care of that for you.
I want to make sure I understand that the phase where that was date of execution hearings. So
It was.
So counsel wants L.A. to be in court for purposes of testifying in the aid and execution.
Yes.
And he's taking the phone calls. Okay.
There was also evidence of continued representation, acting as Complete's lawyer in a series of telephone calls that he participated in with Mr. Galdian, with lawyers involved in the out-of-state litigation after the July 29th termination. He, as attorney at law, he took on the duty as a resident agent on August 15th. He used his attorney email address and even his letterhead in correspondence back and forth with Complete and others. Then we have Laura's questions to him all the time. Was that okay? Was this response good enough? What should I do? It just goes on. And the post hoc explanations for some of these as business discussions related to the business deal, when you look at the overall complexity of their relationship and what was going on back and forth between these two, this was Laura, as CEO of Complete, looking to Mr. Hodge to protect Complete's interest. This was not an arm's length transaction between two independently represented entities, like in the two cases that he cites as examples of business discussions between two businesses. He calls it wrap-up in the Haddon case, but there was no withdrawal. Supreme Court rules require an attorney who's no longer representing somebody to file a motion to withdraw if the client will be left without an attorney. He didn't do that. The August 2nd and September 6th hearing, he didn't give her any written notice of those hearings, and his conduct wasn't consistent with reasonable post-withdrawal efforts to protect her interests. In fact, she got a contempt citation for failure to appear on that last one. So the question for the court is whether, despite the termination, the conduct of the parties here showed that the influence that was created by their attorney-client relationship continued to exist and that she continued to look to him to protect Complete's interests. And the evidence is overwhelming in the record that that was the case. I see I'm out of time. I would submit the rest of the issues on the briefs, except to the extent I can get up and address them in rebuttal.
Do we have any more questions of counsel? Thank you.
Good morning, Mr. Chief Justice and members of the court. I'm Charles Devant, counsel for Mr. Hodge, and I plan to limit my remarks to about 20 minutes if that's okay, because Mr. Hodge would like to address your honors briefly.
Sure, certainly.
May it please the court. This is a case about a young lawyer who acknowledges he made some mistakes back in 2013 toward the start of his legal career. Foremost among them was, at a time when his representation of a client was ending, deciding to pursue a business deal whereby he would buy that corporation's assets. That was a mistake. He deeply regrets that, but it was not a violation of the rules of professional conduct. The hearing panel's report and recommendation here are almost entirely based on the hearing panel's conclusion that Mr. Hodge continued to have an attorney-client relationship throughout the months of August and September of 2013. And we would submit that the clear weight of the evidence is to the contrary.
Wouldn't you agree that if you're right, that the relationship ended on July 29th of 2003, which is your argument? If you're right, then your client violated Rule 1.16A3, right? Because he didn't withdraw from the Haddon litigation, and he's required to, if he in fact has been discharged.
Mr. Hodge concedes it was a mistake for him not to withdraw from that case. It was an oversight. It was
It's a violation of the rule.
I don't know about 1.6A3.
1.16A3 says
Okay.
You shall withdraw when you've been discharged.
That might be the case. I'm not sure. He was not charged with that violation. And
I understand that, but let me tell you why I think it's bothering me. There are several things that are bothering me, so let me just go here for a minute. It bothers me because you make the representation in mitigation of the mistake that you concede that your client investigated the rules and tried to follow the rules. This is a pretty clear rule. If you've been discharged, which is what you say, you got to get out of that case, and you didn't. And so, as much as you can say whether it's a big deal or not, although your client getting found in contempt is a pretty big deal, but regardless of what you say about that, it seems to work against your argument that he researched the rules and in good faith was trying to comply with the rules.
Your Honor, he did research the rules. I don't know that he read all of the rules, and I don't think that he paid attention to Rule 1.16 in particular. If he had, he certainly, I think, would have filed a notice of withdrawal from that case. I will say that Mr. Hodge practices almost exclusively in federal bankruptcy court and had very limited experience in the actual state courts.
This isn't a state court civil proceeding. This is an ethical rule.
I understand.
So, I mean, we all do that. Let me ask you, before I get to a serious thing, let me help you warm up with a housekeeping one.
Yes, sir.
In your exceptions, paragraph 24, and you don't need to look at that in your exceptions, but you made a reference about the panel violating due process by making a preliminary finding that a violation had occurred. So you made that in the exception. I don't actually see that in your briefing. And so am I correct that it's not in the briefing, and so I can kind of disregard that as I process this?
Yes, Your Honor.
Okay. The two things that I consider sort of jaw-dropping in this, and I say jaw-dropping because I can remember exactly where I was sitting when I was reading this stuff in my house a few weeks ago. And I don't often do that, remember where I was sitting. But the two that I want you to focus on is his preparation of the corporate resolution and the director's minutes. When you say he's doesn't have his lawyer hat on, I don't know how you can, I mean, I'll just tell you, I don't know how you can do those documents and not have a lawyer hat on. So that's the first one I want you to talk about. The second one is the back and forth with Aaron. Now that your client knows that Complete is represented by another attorney in a bankruptcy proceeding, and that bankruptcy proceeding clearly could be seen to be adverse to his business proposition, he's giving legal advice to these two individuals that constitute the shareholders of Complete that's contrary to what Mr. Aaron's saying. And Mr. Aaron is saying, stop talking to my clients, and he keeps talking. And so those are the two things that I can't reconcile against your arguments in your brief. So let me turn you loose with those two.
Okay, Your Honor, I'll take the second one first, which is the back and forth with Mr. Aaron. The finding of a Rule 4.2 violation by the hearing panel was based on a single email, one email, and as a result of that email, Mr. Aaron told Mr. Hodge, don't talk to my clients anymore, and he stopped. That was it. So it's not a situation factually where he continued to communicate with them after Mr. Aaron asked him not to do it. So this is just a single email, and Mr. Hodge believed, I think consistent with the plain text of 4.2, that he was entitled as a party to talk to another party, because the language of Rule 4.2 says, it begins with the words, in representing a client, comma, a lawyer shall not communicate with a represented party. And Mr. Hodge at this point was not representing a client. He was acting on his own. With regard to the...
So your position is he wasn't representing Hodge Associates or assets, whatever that one was called, and then the landscaping business.
Correct. That is, the position is he was not acting as a lawyer for his own business entities at that point in time. There was no attorney-client relationship between himself and his own wholly owned companies. With regard to the preparation of the corporate documents, I think it is not at all unusual for a lawyer to prepare documents for a transaction. For example, if I'm representing a client in a civil lawsuit and there's going to be a settlement, oftentimes the lawyers on both sides will race to prepare the settlement agreement and then submit it to the other side because you prefer that they use your documents. That's just one example. The mere fact of preparing legal documents does not in and of itself establish an attorney-client relationship. And it's important to remember the context here. At the time this has taken place, Mr. Hodge had written to the CEO, please reply to my email stating that you do or do not wish for my office to disengage in representation. And the CEO responded, please disengage as legal representation for CLS. And it went on and on. There were multiple communications like this. She wrote, quote, you don't legally represent CLS. She wrote to someone else, quote, Rick Hodge is not representing CLS. She wrote, let's just clarify for the umpteenth time, Mr. Hodge is not my legal representation. Mr. Hodge thought his attorney-client relationship was over. The rules, comment 3, for example, to Rule 1.3 says, doubt about whether a client-lawyer relationship still exists should be clarified by the lawyer, preferably in writing, so that the client will not mistakenly suppose the lawyer is looking after the client's affairs when the lawyer has ceased to do so.
Counsel, a few minutes ago, prior to the exchange with my colleague, you said that your client acknowledges or concedes he made mistakes, and specifically made a mistake in attempting to acquire the assets of the business, but maintains that those were not violations of the rules of professional conduct. What does he think the mistake was?
The mistake was to mingle his affairs with that of a former client, the way he did. I think he accepts that that was a very bad judgment at the time. It's something that he will never do again.
Why was he doing that, from your perspective?
I think he thought as a lawyer there was nothing else he could do in this situation.
But why was he doing that? I mean, what was let's just concede for the purpose of my question, it's a mistake, the way you just described it. I mean, there's still a reason for that. Like, why did he make that mistake? What did he hope to achieve?
I think he thought he could structure a deal that would benefit everyone and help everyone.
So he was just philanthropically inclined. There was no motive to enrich himself in this whatsoever. That's your position?
No, that's not my position. I think he thought that the ship was sinking. They were in trouble on the ship. He could help everyone, including himself, by pursuing this transaction. He thought this would be a better outcome for everyone. And he thought it would be a better outcome than Chapter 11. And his client told him at the very beginning and repeatedly thereafter that she was dead set against Chapter 11 for CLS. So it was in that context, and when he had...
I guess my question then is, even if we were to accept all your arguments about who was representing who when, I mean, how does what you've just described not at least potentially fit 8.4 anyway? I mean, to come into this situation and say, I can profit here. And then maybe I even technically discharge all my lawyerly responsibilities. I mean, at some point there is simply conduct that adversely reflects on the fitness to practice law, is there not?
I think that's right. I don't think this rises to that level. And lawyers can do business with clients. It happens all the time. And when you do business with a client, you get informed consent. And that is what he tried to do here. You know, in addition to documenting that he was no longer looking out for CLS as its counsel, he wrote to them, I have a conflict of interest here. He wrote to them, I have some knowledge of CLS's financial doings. He wrote to them, you are advised to get independent counsel. He did the things that he thought were required to comply with the rules, and it was always his intention to comply with the rules.
At the time your client prepared the minutes and the corporate resolution, he knew that Folston had been hired to deal with the non-compete between, the initials don't work very well for me, from Peter and Laura, right?
I believe that's correct.
Okay, so, and the resolution and the minutes deal with the non-compete that Folston's supposed to be doing, right?
Correct.
How can he send a document that deals with the non-compete at all when he knows another lawyer's been hired to do that?
Well, again, Your Honor, he was not representing a client, so
So you're just saying he doesn't have the hat on?
No, I'm not. I'm saying quite the opposite. I mean, Rule 4.2 says, in representing a client, a lawyer shall not. So
What's he doing, preparing documents that have legal effects between two people and sending them off, and he's got his email and it says, attorney on it. Mm-hmm. I mean, this is a legal document. You just don't, I mean, it's either well, it's not that, but I don't see how you communicate with somebody you know's got a lawyer on a specific legal matter and send them a document that affects the matter that the lawyer's been retained on.
Yeah, and if you look, for example, at the Connecticut Supreme Court decision in Pinsky, the court there said that a lawyer has a right to make such a communication when he is not representing a client. And that is exactly the situation that was existing at the time of this. It's not that he was taking his lawyer hat on and off. He thought the relationship was over, that had been documented and documented and documented.
I'm sorry, I didn't mean to cut you off.
Oh, no, sir.
In your view, was he practicing law when he was drafting these documents?
No, Your Honor, because one cannot practice law without client.
Well,
He was
that
acting
leads
on
me-
his own account. I mean, if a layman had drafted these documents, then that layman would not be in trouble for the unauthorized practice of law because he's not a lawyer. There is no unauthorized practice of law outside of an attorney-client relationship.
So it's your view that he was drafting these documents for himself?
Correct. That's exactly right. If I could turn, Your Honor, to the question of sanction in the event that there is a finding he violated the rules. It's important to remember this is not a case where a lawyer set out to try to violate the rules. This is a case of a very young lawyer who tried to do what he thought the rules required him to do, which were to terminate the relationship, to make sure the client understood that by documenting it in writing, by advising her of the conflict and the other steps that he took.
The rules don't have a requirement of intentional conduct, though, or of malevolent intent.
That's exactly right. It is possible to violate the rules negligently.
We have people who are sanctioned all the time in Kansas for negligently screwing up.
And this is such a case, Your Honor, because he did not set out to violate the rules. He misjudged, at worst, how the rules would be interpreted in this very strange situation where he thought he had terminated the relationship, but someone after the fact was able to infer on the basis of his communications that perhaps the client still thought a relationship was continuing. Many courts have held that that type of a mistake where one screws up the application of the rules is a negligent violation of the rules, not a knowing violation of the rules. In fact, you need to know the rules to knowingly violate the rules. And this is not that case because the case law is very clear. There are several cases that are very similar to this one where terminations in writing, like Mr. Hodges, have been deemed effective and have effectively insulated lawyers from liability or from finding of disciplinary violations. So this is a case where he tried to comply with the rules and at worst negligently failed to comply with them. And this court has written that the presumptive sanction in that type of a situation is short of disbarment, short of suspension, it's either a censure or a even lesser standard, which we would submit would be appropriate, especially in light of the mitigating factors here, the fact that Mr. Hodges, a very young lawyer, he was even younger back in 2013 when this happened. He's never been disciplined. This is a completely isolated event in his legal career. There's no dispute that he showed a cooperative attitude toward the disciplinary process. Although he disagrees with the disciplinary administrator's legal interpretation, he's deeply remorseful about this conduct. He is, and this was a specific finding of the hearing panel, an active and productive member of the bar who enjoys the respect of his peers and generally possesses a good character and reputation. This conduct occurred more than 4 years ago. He's not had a single docketed complaint in the last 4 years. He has, in the last few months, performed voluntarily 16 hours of CLE just focused on ethics issues. He is determined never to come near the line again, as he acknowledges he did in this case. He is determined to be a valuable member of the bar, and frankly, he is a good person, and he's the kind of person that will be a credit to your bar.
Counsel, what was your client's first belief or acknowledgement that, oh, maybe there's an ethical issue here, when he got a copy of the complaint that was served?
I am not sure, Your Honor, what the timing of that was. I know that at the hearing itself, he was expressed remorse.
But do you know before he got the complaint if he ever said to himself or to somebody else, maybe there's an ethical issue here? Or is he completely oblivious to that possibility?
I think he thought there was an ethical issue, and I think he thought he addressed that with the writings that he provided to the client, saying that the relationship was over and that he had a conflict and that he had knowledge of CLS's financial status. So in other words, I think he spotted the issue. He thought he had appropriately dealt with it at the time.
So it would be your position that when he learned of this complaint, he was stunned?
I think, I don't know that because there was litigation afterward. There was a sort of falling out with the CEO of the company. So I don't know if he was surprised or not by the filing of the bar complaint, which occurred in that context.
All right, thank you. Did you have any further presentation?
No, Your Honor. Thank you very much.
Before you sit down, let me ask, do we have any more questions of counsel? All right, thank you.
May it please the court, Justices, Rick Hodge responded. First and foremost, I've listened to the questions you've asked my attorneys. And before I address what I wish to say to the court, I think it's incumbent upon me to apologize. I feel quite dumb, for lack of better words. I thought I was acting wisely. I thought I had engaged in the appropriate conduct pursuant to my understanding of the rules, but I look back and I realize I was unwise. In 2013, I had been practicing law for 4 years, and I thought I knew more than I knew at the time. I've heard the arguments this morning that this court was presented with about very serious, very egregious issues, and I feel awful for wasting this court's time to deal with me. And I feel awful that I was young and dumb. I thought I could help, and what I did was a mistake. I acted unwisely. Wisdom is the application of the sum of knowledge and experience, and I acted unwisely. I had a little bit of knowledge and a little bit of experience. I wish to convey a very heartfelt apology to all parties involved. I do regret my actions. I am remorseful. I am an ethical person. In fact, I admonish myself for my actions. Looking back 4 years later, I didn't know what I didn't know, and I apologize. Your Honor, Justices, I have taken additional correspondence work and seminar work in ethics because I want to make sure that I have a broad depth and breadth of the rules of professional conduct and how it applies to our practice, because a happy lawyer is also an ethical lawyer. I want to make sure that I convey to this court, to the bar, and to the general public that I hold myself accountable for my actions, and I do. I also want my actions to be of the highest level of professionalism and the highest level of ethics, because I value my law license. I value the help that I can provide to the public. I've also put together a team, if you will, of counsel, much more experienced than I am, 20, 30, 40 years of experience. Some men and women who were on the bench and who have since left to answer questions for me and to advise me, to give me insight that I didn't have at the time in 2013. If this court sees fit for me to continue to practice law, of course I will do more than the bare minimum for the ethical responsibilities that we're required every year, the 2 hours, in addition to consulting with these attorneys, because they have a wealth of information and a wealth of knowledge. When I went to law school, I went from Wichita, Kansas to Oklahoma. I drove 2 hours and 26 minutes one way, took my coursework, and then drove 2 hours and 26 minutes back to Wichita. My family was in Wichita, my wife, my children, my support network, occupation, and the burden was mine to bear, but I valued the law degree. The second and third year, I drove 2 days a week down and back, 2 hours and 26 minutes one way. Ultimately, I passed the bar and I went into the insolvency practice because in that area, I felt that I could best help to keep families together. Economic problems were plaguing the United States, and Kansas was not inoculated from those effects. I could keep families together. I could give them stable footing, security. I could help to make sure their families were fed. The things that I saw tugged at my heartstrings, and I'm sure they would yours as well. I enjoy what I do. My staff and I have over 2,000 active cases. We've helped over 2,000 families. That is the work that I do. I've not had any problems in that line of work. This is an isolated incident, but ultimately I take responsibility. I take personal accountability for what I do. And I don't know that there's anything that I could say to convey to this court how bad I feel, that it will never happen again, that I am not a threat to the public, that I am not a threat to the bar. I would never engage in conduct that would harm anybody, that would harm the bar, that would harm the trust that the public places in us as attorneys. That is not who I am. My rap sheet consists of a few speeding tickets in the early 2000s, and I got my name on the board in grade school for talking in class. That is what I have done in my past. I thoroughly enjoy helping people. I'm a problem solver. Give me a problem that you say is not solvable, and I will go to task on it, because that is my personality and that's what I enjoy. Questions were raised about benevolence. Yes, I do enjoy helping people. And with my law license, I'm able to do amazing things. I feel amazing things. But I'm also a non-professional. I'm a parishioner at my church. I'm a husband. I'm a father. I'm a businessman. I'm a son. I'm a brother. I do so many other things outside of the practice of law. And as mistaken as I probably was, I believed that I could compartmentalize. And looking back now, I would never do it again. I think it's too close to the line. I think nothing good can come from it. But I compartmentalized. I can be an attorney. And when I'm no longer an attorney, when I am told I'm no longer an attorney, I can be a businessman. And I can help in a capacity, in a form, and a fashion that benefits everybody, myself included. Is that self-dealing? That's for this court to decide. But that's the way I looked at the situation. And in looking at Rule 1.16, the rule said that the client has the right to terminate the attorney for any reason. I learned that we can rely on the rules as attorneys, not only to protect the public, but to protect us. I thought I was doing the right thing by putting everything in writing, by putting the information down, by clearly conveying what I saw and the options. And the mistake that I made was getting too close. The mistake that I made was being unwise and not consulting with senior counsel, asking questions. And for that, I'm deeply regretful. I will say that my law license is valuable to me. I can definitively stand before you and say there's one person that is alive today because I believe of my law license. Without sounding self-serving, 2 years ago, Your Honor, Justices, there was a gentleman who had dire financial straits. He made some bad decisions and some bad things happened to him. Wasn't getting along with his wife, couldn't pay his mortgage bills. For 3 or 4 months, he toiled with a mechanism, a method to solve this problem. And I found out that the only solution that he could find involved a bullet and a gun. One day he woke up and he wrote a suicide note, put it in his lunchbox, drove to work, spent the morning at work, and at lunchtime he left his lunchbox in the lunchroom. And he left Spirit Aerosystems, a company in Wichita, to carry out his task. He heard a radio advertisement that said something to the effect, you don't have to live with debts you can't pay. You don't have to live in hopelessness. Help is available. You have nothing to lose and everything to gain. Please call, come see us. He didn't call. He actually showed up at my office. and he said, "There's an emergency, can I talk to somebody?" We sat down and visited with this man. He was in his mid-50s, he was a machine operator, a man's man. I grew up on a farm, raising cattle with horses. Big men, big muscles. You would look at him and you would think, this man never sheds a tear. He cried in my office like a baby. He told me and my staff what was going on in his life and how bad it was. Within an hour and a half's time, we'd realized that he didn't know what he didn't know. Help was available, and his problems were not as bad as he thought. When he left my office, Justices, he had a handful of hope, something I don't think he'd had for a long time. And I've seen that in my practice, because that's what we do for folks. He was supposed to come back the next day with some documents so we could get started working on this plan of attack to solve his problems. I thought I would see him the next day. I didn't see him the next day. I saw him 45 minutes later. He came back with his lunchbox, and when he opened it, there was the note. He gave us the note, and that note sits in my office today as a reminder that we don't necessarily know the impact that we have on people. And we can do things that are impactful in a bad way, and I don't want that. I don't think any lawyer wants that. But we can also do things that are impactful in a good way. And my staff and I look at that note, and we'll conversate about that every so often, because that reminds us we're here for a limited time to do good work. And if the good work is with our lawyer hat on, Justice, as you say, or if our good work is in our churches or in our communities, absent and apart from a lawyer, we're still doing good work, but we can do those things in multiple capacities. This man is actually doing well. He and his wife are still together, and as I understand, he actually has his first grandbaby. That's exciting. I own my responsibilities. Again, there's nothing that I can say or do that can impart any more comfort upon this court than I already have. I will not engage in conduct that is close to the line. I regret my actions deeply and sincerely. I regret my actions. People come to me all the time asking for a second chance. I believe in second chances. That's why I do what I do. And I hope this court does too, because I'm standing before you today asking for the same. Thank you for your time.
Thank you. Do we have any questions for either counsel? All right, thank you both.
Thank you.
You reserve 7 minutes for rebuttal.
First, if I may, I'd like to address one of the things that you, Justice Biles, asked Mr. Hodges' counsel to address, and that was the email legal advice to the two shareholders on September 24th. And I want to address that because for my position on that is that underscores the evidence of the attorney-client relationship that continued after that July 29th email. And here's how it underscores that. When Laura finally broke free of the continuing influence of that attorney-client relationship, when she retained Dave Aaron and he was ready to file bankruptcy, advised her to do so, and she was on board, and Mr. Hodge learned of that, he used every tool that he had, including improper legal advice to her, contacting what he knew as a represented party to try to bring her back under his influence and essentially to avoid that bankruptcy that he had been telling her from the start to not do, because now it was imminent. And it contained legal advice. It was pure legal advice. And to say, just briefly touching on the 4.2 issue, which is briefed, but I want to say on that email, he says that he was not acting as a lawyer at all. He wasn't even representing yard concerns in writing that email to Laura and Peter. But the email was sent from his attorney law firm email address. It went to Laura, and Laura sent a reply to him and said, you know, I am interested in talking with you about this. And then in that email chain, he responded back to Laura, again from the attorney email address, and this time his response saying, let's meet at, I think, 3 o'clock or wherever at such and such a place, had his attorney letterhead on it, Rick Hodge, attorney at law. So not only do we have an email that was full of legal advice to her, but it's from his attorney email, and that's not even all. it has his letterhead on it. But whose attorney was he? He was giving her legal advice to a represented party. He clearly represents Yard Concerns, who was the one trying to buy the business assets and avoid this bankruptcy. So, you know, the idea that he was just a non-lawyer party within the meaning of Rule 4.2 that allows parties to contact each other, it just doesn't fly.
Counsel, along those lines, from your perspective, is the 8.4 violation independent, or does it sort of sit on top of the other violations that in turn sit on top of this interpretation of whether or not there was a lawyer-client relationship?
The hearing panel based the 8.4 violation on several things, the first of which was just the extent of the self-dealing here. That this pattern of self-dealing began as soon as he saw what he was looking at, and the scope.
And again, can self-dealing exist apart from the attorney-client relationship?
Well, yes, 1.8a does allow an attorney to enter into a business relationship with a client, clearly, if 3 very strict requirements are met, which, as argued in the brief, they were not met here. But it is not, it's not against the rules for an attorney to self-deal in the sense of entering into a business relationship with a client. With full consent, full and meaningful advice to seek independent counsel, consent confirmed in writing, and that the terms are fair and reasonable to the client, then absolutely. That kind of self-dealing. But the egregiousness of the self-dealing that we have here in violation of 1.8 is what the hearing panel found rose to the level of an 8.4G.
While we've got a pause here, the finding that L.A. was vulnerable by the panel was based upon her lack of legal experience, and we pretty well dealt with that in the Barker case, right? In other words, I don't think that hearing panel finding is going to survive our previous case law that says legal inexperience alone is not enough to make you vulnerable.
I am not familiar with that holding off the top of my head. I would have to review that.
Because I didn't see it in your brief, and or even discussed in your brief. And we've said that financial pressure and that kind of thing can make you vulnerable, but when and the holding of the panel was just based on her being inexperienced, and I remember that case because I dissented on it, but it's a different matter.
I'm sorry, I don't know
so
that one off the top of my head.
Then address that. Why do you think there's authority to find her vulnerable when the factual basis for it is just the fact that she has limited legal experience? Seems like all clients come to the party with that.
She was vulnerable, not just the lack of legal experience, but she was vulnerable because what she didn't know and wasn't told to her made her vulnerable. I mean, she's being told not to file bankruptcy, and the argument was, she had lawyers. She'd been dealing with lawyers as a CEO of a big corporation, successful corporation for many years. She should have just been, she wasn't vulnerable. She was able to deal with this kind of stuff, could surely protect herself. But just a regular business person doesn't have the highly specialized knowledge that you would need to know to understand how exactly Chapter 11 could have benefited her company in this situation. I mean, who knows that? That's why they're specialized attorneys that handle that. Even regular attorneys don't know that. I had to be schooled on it, certainly. So how would she know what a 363 sale was and that this asset sale was impossible other than through Chapter 11 bankruptcy?
That's still sort of a version of legal, lack of legal knowledge or legal inexperience.
Right.
Is she vulnerable here just because she's on the ropes financially?
Tremendously so. I mean,
and is that sufficient to meet the vulnerability factor?
I argued that as well. As you read the text messages and the emails, her desperation just clearly comes throughout all of it.
And I don't disagree with any of that. It's just I'm stuck with what the panel found. And the panel said she was not experienced she was an experienced businesswoman, she was not experienced in legal matters and relied to her detriment on the respondent, she was vulnerable to his misconduct. That's all it says. And so I'm trying to see whether the evidence supports that by clear and convincing evidence, and as a question of law, and that's the problem.
I'll have to defer on
Okay.
the case that you're referring to, and I apologize for that. Just to wrap up then, I ask that the court affirm the hearing panel's conclusions, findings and conclusions, and impose the recommended sanction of disbarment. My alternative recommendation on suspension I made before the hearing panel was if the court were to find that disbarment is too severe, then my alternative request would be for indefinite suspension.
Any further questions? Thank you, counsel. I thank all counsel for your arguments this morning and this afternoon. Court will take this matter under advisement. That concludes